All right, before we head back to court, folks, I want to bring back in criminal defense attorney and former head prosecutor Bob Bianchi to discuss. Bob, talk to me a little bit about the burden of proof here. We just heard the attorney for Cardi B talking about it. He mentioned it. He said something about 50%, that the plaintiff has to come up to 50%, then go beyond it. It's a preponderance of the evidence. He talked about it being more likely than not. Talk to me a little bit about that standard of proof.
Well, you know, that's it. You just nailed it. That's what the judges say, right? It's a preponderance of evidence, slightly more than 50%, you know, more likely than not. And the reason I'm laughing is that a lot of times, I don't know how you guys feel, but you're in court and you're trying a case and you're listening to the jury charges, and as a lawyer who's been through these jury charges a million times before, you kind of laugh internally to yourself saying, I don't even understand what the jury charges even mean, and yet we're requiring the jury to understand it. So it's the best approximation that a court can give through words, which are limiting, that it just can't be a 50-50. Tie does not go to the plaintiff. A tie goes to the defense. Anything more than that, however slight, is the level of proof that you need. And sometimes I like when judges compare it to things like proof beyond a reasonable doubt, so they can give the jurors an understanding of the distinction between those two things. Of course, proof beyond a reasonable doubt being a much higher burden.
Well, I was going to say the preponderance is the lowest burden. There's clear and convincing after that, and then proof beyond a reasonable doubt. So I said to Michael, wow, I can't believe it's that low, but he pointed out in civil cases it frequently is. Only 6 states is it a higher clear and convincing. So it's not a very high burden for a plaintiff to have to meet. But I want you to pick up with something you said earlier, which is you haven't heard evidence. I'm putting words in your mouth. I don't think you have heard evidence that would convince you there needs to be a finding for the plaintiff if you were on the jury. Is that accurate, and why if so?
I mean, the bottom line here is that the jury charge is only as good as the jurors that don't nullify it. Or, in other words, say, we are just not going to put our imprimatur on finding a liability here. Now, what jurors could do, because, look, I used to be a plaintiff's lawyer in civil cases. So when I'm evaluating a case, I look at, is there liability? When we're talking about preponderance of the evidence, we're saying, is there enough evidence to establish by a preponderance of the evidence, just more than 50%, that there's liability? But the second part of the equation is huge, too. If there is, what are the damages? What is the value of the case? And obviously, if somebody gets, I used to use this example, run over by a car, picks themselves up, dusts themselves off, and walks on and doesn't have any injury, that's a bad case. Liability's high. Damages are bad. The damages are low. So me taking this case on as a lawyer, as a plaintiff's lawyer, to me is a Hail Mary pass to be involved in something where you're a big shot, you're going after a big shot, you're getting a name for yourself, and you know what? If you get a couple of dollars out of it, that's great. But what are the damages here? Nobody would have brought this case if it wasn't Cardi B. The case stinks.
Yeah, I mean, they could find liability and then not find damages per se. Just compensate her for the cost of whatever medical they decide happened, and then just let it be a day. And one final question for you, Bob. How did Cardi come across to you? I've heard her described many different ways. Charming, funny, a bit too angry, too glam, disrespectful. How do you think she came across to the jury?
God, those are all the adjectives I want to describe myself. So, look, I mean, I think she came across well. Okay, I think that one of the things that I tell anyone when they're in court is be yourself. Now, you may tone it down a little bit, but it becomes antiseptic and not real. And I think people like real, and they're willing to take a little bit of some zip on the fastball, or maybe a little bit of an attitude. Look, she's a big star. She's a famous person, so I don't think that deprecates her. I think some jurors are going to find her endearing, which can only help her.
Yeah, I would agree too. All right, let's get back inside the courtroom now, Bob.